Visa or green card. One wrong move destroys everything. Millions of people living in Florida confuse a visa with a green card every single day. They are completely different legal statuses with different rights, different timelines, and different consequences if violated. Understanding this difference could protect your future in America. Here's exactly what every immigrant in Florida needs to know. The fundamental legal difference. A visa and a green card are two entirely different immigration statuses under United States federal immigration law governed by the Immigration and Nationality Act. Understanding the core distinction between them is the foundation of every immigration decision you will ever make. A visa is temporary permission granted by the United States government that allows a foreign national to travel to the United States and remain here for a specific, limited purpose and a defined period of time. Every visa has conditions attached to it. When those conditions end or expire, your legal right to remain in the United States ends with them. Overstaying a visa, even by a single day, creates serious legal consequences that can follow you for years or permanently bar you from returning. A green card, formerly called a permanent resident card, is an entirely different category of immigration status. It is officially known as lawful permanent resident status under the Immigration and Nationality Act. A green card grants you the legal right to live and work permanently in the United States without any time restriction tied to a specific employer, school, or purpose. You are not a United States citizen, but your right to remain in the country is not tied to a temporary condition expiring. What a visa actually is and how it works. The United States issues dozens of different visa categories, each designed for a specific purpose. Visas fall into two broad categories under federal immigration law: non-immigrant visas and immigrant visas. Non-immigrant visas are temporary and purpose-specific. The most common non-immigrant visas that Florida residents and visitors encounter include the B-1 and B-2 visas for business visitors and tourists, the F-1 visa for full-time academic students, the H-1B visa for specialty occupation workers in fields requiring at least a bachelor's degree, the H-2A visa for temporary agricultural workers, the L-1 visa for intra-company transferees, the O-1 visa for individuals with extraordinary ability in their field, the J-1 visa for exchange visitors and certain medical graduates, and the TN visa for Canadian and Mexican professionals under the United States-Mexico-Canada Agreement. Each non-immigrant visa has specific rules governing what you can and cannot do while in the United States. An F-1 student visa holder generally cannot work off campus without specific authorization. A B-2 tourist visa holder cannot enroll in a degree program or work in any capacity. Violating the conditions of your visa status, even without leaving the country, constitutes a status violation that can result in removal proceedings and future bars on admission. Immigrant visas are different. An immigrant visa is issued to a foreign national who has already been approved for lawful permanent resident status and needs to travel to the United States to complete the process of obtaining their green card. An immigrant visa is essentially the final travel document that converts into a green card upon entry. What a green card actually is and what it gives you. A green card grants lawful permanent resident status under the Immigration and Nationality Act. As a green card holder in Florida, you have the legal right to live anywhere in the United States permanently, work for any employer in any lawful occupation without employer sponsorship, own property, access most federal benefits after meeting eligibility requirements, sponsor certain family members for their own immigration benefits, and travel internationally and return to the United States as your permanent home. A green card is issued with a 10-year validity period and must be renewed before it expires. However, the underlying lawful permanent resident status does not expire when the card expires. The card is simply evidence of your status. Conditional permanent residence, which includes certain spouses of United States citizens married for less than 2 years, and certain immigrant investors, receive a 2-year green card and must file to remove conditions before that card expires under the Immigration and Nationality Act. The 4 main pathways to a green card. Family-based immigration. The most common pathway to a green card in Florida is through a qualifying family relationship with a United States citizen or existing lawful permanent resident. Immediate relatives of United States citizens, meaning spouses, unmarried children under 21, and parents of adult citizens, receive the highest priority under the Immigration and Nationality Act and are not subject to annual numerical visa caps. This means their cases can move forward as soon as the petition is approved. Other family preference categories, including adult children, married children, and siblings of United States citizens, are subject to annual numerical limits and can involve waiting periods ranging from several years to over a decade, depending on the applicant's country of birth. Employment-based immigration, a green card, can be obtained through employer sponsorship across 5 employment-based preference categories. The EB-1 category covers priority workers, including persons of extraordinary ability, outstanding professors and researchers, and multinational executives and managers. The EB-2 category covers professionals with advanced degrees or exceptional ability. The EB-3 category covers skilled workers, professionals, and unskilled workers. The EB-4 and EB-5 categories cover special immigrants and immigrant investors, respectively. Most employment-based green cards require the employer to complete a labor certification process through the Department of Labor before filing the immigrant petition. Asylum and refugee status foreign nationals who have been granted asylum in the United States or admitted as refugees can apply for a green card 1 year after receiving that status under the Immigration and Nationality Act. Florida has a significant asylum-seeking population, and this pathway is critically important for many Florida residents who came to the United States fleeing persecution based on race, religion, nationality, political opinion, or membership in a particular social group. Diversity Visa Lottery. Each year, the United States government makes up to 55,000 immigrant visas available through the Diversity Visa Program under Section 203C of the Immigration and Nationality Act. Applicants from countries with historically low rates of immigration to the United States are eligible to enter. Winners are selected randomly by computer lottery and must meet education or work experience requirements to qualify. Florida residents from eligible countries can participate in this program each year during the annual registration period. Key differences that affect daily life in Florida. Work authorization. A visa holder's ability to work in the United States depends entirely on the specific visa category. Many visa categories prohibit employment entirely. A green card holder has unrestricted work authorization for any lawful employer anywhere in the United States with no additional filing required. Travel. A visa holder who travels outside the United States must ensure their visa remains valid for re-entry and that their period of authorized stay has not expired. A green card holder can generally travel internationally and return to the United States as their permanent home, though absences of more than 6 months can raise questions about abandonment of residence, and absences of more than 1 year without a re-entry permit can result in loss of permanent resident status. Path to citizenship. A visa holder has no direct path to citizenship based on visa status alone. A green card holder becomes eligible to apply for United States citizenship through naturalization after 5 years of continuous permanent residence, or 3 years if the green card was obtained through marriage to a United States citizen, under 8 U.S.C. Section 1427. Deportability. Both visa holders and green card holders can be removed from the United States for certain criminal convictions or immigration violations. However, the legal standards and available defenses differ significantly between the two statuses, making qualified legal representation essential in any removal proceeding. A visa gives you temporary permission tied to a specific purpose. A green card gives you the permanent right to call the United States your home. Every person navigating the United States immigration system in Florida needs to understand exactly where they stand, what their current status allows, and what steps lead toward permanent residence and eventual citizenship. Whether you're on a visa, pursuing a green card, or facing any immigration challenge in Florida or Nevada, visit yandizalaw.com right now. The attorneys at Y&Z Law understand immigration law and will guide you through every step of your case. The link is in the description. Your future in America is worth protecting today. Subscribe for more real legal guidance, because understanding your immigration status is the first step to securing your future.